Hello everyone, welcome to my channel. This video is about interpretation or construction of statute. It is an age-old process and as old as language. It is well settled principle of law that as the statute is an edict of the legislature, the conventional way of interpreting a statute is to seek the intention of the legislature. The intention may be of two aspects. One carries the concept of meaning and other conveys the concept of purpose and object or the reason or spirit pervading through the statute. The process of construction therefore combines both the literal and purposive of approaches. So, what is statute? Mainly defined as the will of the legislature. Normally, it is denoted as the act enacted by the legislature. A statute is thus a written will of the legislature expressed according to the form necessary to constitute it. The Constitution of India does not use the term statute, but it employs the term law as to describe an exercise of legislative power. Statutes are commonly divided into following classes. Codifying, when they codify the unwritten law on a subject. Declaratory, when they do not profess to make any alteration in the existing law, but merely declare or explain what it is. Statute can be remedial when they alter the common law or the judge-made law, or amending when they alter the statute law, consolidating when they consolidate several previous statutes relating to the same subject matter with or without alteration of substance, enabling when they remove a restriction or disability, disabling or restraining when they restrain the alienation of property, penal when they impose a penalty or forfeiture upon the law abider. Now, what is the need and object for interpretation of statutes? The need arises from where the language of a statute provision is ambiguous, not clear, or where two views are possible, or even where the provision gives a different meaning, defeating the object of the statute. If the language is clear and unambiguous, there is no need for interpretation. But for the purpose of construction or interpretation, the court obviously has to take recourse to various internal and external aids. These internal aids include long title, preamble, heading, notes, illustrations, whereas the internal aids, when not adequate, court has to take a recourse to the external aids. It may be parliamentary material, historical background, reports of a committee or a commission, official statement, dictionary meanings, or foreign decisions even. Now, at the outset, it must be clarified that it is when only the intention of the legislature, as expressed in the statute, is not clear, the court is interpreting, it will have to need certain rules, certain principles which need to be followed. There are certain rules such as the literal construction, the mischief rule, even the rule of reasonable construction and harmonious construction, also the rule of justum generis. We'll see all this one at a time. The first is the primary rule known as the literal construction. According to this rule, the words, phrases, and sentences of a statute are ordinarily to be understood in their natural, ordinary, or popular and grammatical meaning, unless such a construction leads to an absurdity or the content or the object of the statute suggests a different meaning. The objectives, natural, ordinary, and popular, are used interchangeably. If there is nothing to modify, alter, or qualify the language which the statute contains, it must be construed according to the ordinary and natural meaning of the words. The safer and the more correct course of dealing with the question of a construction is to take words themselves and arrive, if possible, at the meaning without, in the first instance, reference to cases. Whenever you have to construe a statute or a document, you do not construe it according to the mere ordinary general meaning of the words, but according to the ordinary meaning of the words as applied to the subject matter with regard to which they are used. A construction which would leave without effect any part of the language of a statute would normally be rejected. Thus, where an act plainly gave an appeal from one quarter sessions to another, it was observed that such a provision, though extraordinary and perhaps an oversight, could not be eliminated. Some of the basic principles of literal construction are: every word in the law should be given meaning, as no word is unnecessarily used. Another principle is that one should not presume any omissions, and if a word is not there in the statute, it shall not be given any meaning. So, this was literal construction. The next is the mischief rule, also known as the Haydon's rule. In Haydon's case, in 1584, it was resolved that for the sure and true interpretation of all statutes in general, be it penal or restrictive, four things were to be discovered and considered. Number one, what was the common law before making of the act? Number two, what was the mischief and defect for which the common law did not provide? Third, what remedy the Parliament has resolved and appointed to cure the disease for the Commonwealth? And number four, the true reason of the remedy. Although judges are unlikely to propound formally in their judgments the four questions, but the enactment in the common will often provide the solution to a problem of interpretation. Therefore, when the material words are capable of bearing two or more construction, the most firmly established rule of construction of such word is the rule laid down in the mischief rule, which has now attained the status of a classic. The rule directs that a court must adopt the construction which shall suppress the mischief and advance the remedy. This rule is also known as the beneficial and the purposal rule. Another rule is the rule of reasonable construction, also known as the golden rule. Normally, the words used in a statute have to be construed in their ordinary meaning. But in many cases, judicial approach finds that the simple device of adopting the ordinary meaning of the words does not meet the ends as a fair and reasonable construction. Therefore, exclusive reliance on the bare dictionary meaning of the words may not necessarily adopt, and in which often interpreting the provision it becomes necessary to have regard to the subject matter of the statute and the object which it intended to achieve. Therefore, according to this rule, the words of a statute must be construed ut res magis valeat quam periet, meaning ordinary meaning, so as to give a sensible meaning to them. A provision of law to be so interpreted cannot be entirely divorced from the common sense. Every word or expression used in the act should receive a natural and fair meaning. Therefore, it is the duty of a court in construing a statute to give effect to the intention of the legislature. If, therefore, giving of literal meaning to a word used by the draftsman, particularly in penal statute, would defeat the object of the legislature, which is to suppress a mischief, the court can depart from the dictionary meaning which will advance the remedy and surpass the mischief. The next is the rule of harmonious construction. A statute must be read as a whole, and one provision of the act should be construed with reference to other provisions in the same act, so as to make a consistent enactment of the whole statute. Such a construction has the merit of avoiding any inconsistency either within a section or between a section and other parts of the statute. It is the duty of the courts to avoid a head-on clash between two sections of the same act, and whenever it is possible to do so, to construct provisions which appear to conflict so that they harmonize. Wherein an enactment there are two provisions which cannot be reconciled with each other, they should be so interpreted that if possible, effect may be given to both. This is what is known as the rule of harmonious construction. This was applied in the case of Keshav Nanda Bharti versus State of Kerala. The next rule is the rule of justem generis, which literally means of the same kind of species. This rule can be stated in an enumeration of different subjects in an act, general words following specific words may be construed with reference to the antecedent matters, and the construction may be narrowed down by treating them as applying to things of the same kind as those previously mentioned, unless, of course, there is something to show that a wide sense was intended. Also, if a particular word exhausts the whole genus, then the general words are construed as embracing a larger genus. To apply the rule, the following conditions must exist. The statute contains an enumeration by specific words. The members of the enumeration constitute a class. The class is not exhausted by enumeration. A general term follows the enumeration. There is a distinct genus which comprises more than one species, and there is no clearly manifested intent that the general term be given in a broader meaning that the doctrine requires. The rule of justem generis must be applied with great caution because it implies a departure from the natural meaning of the word in order to give them a meaning or supposed intention of the legislature. The rule must be construed by the fundamental rule that statutes must be construed so as to carry out the object sought to be accomplished. The rule requires the specific words are all of one genus, in which state the general words may be presumed to be restricted. Whether the rule of justem generis should apply or not to a particular provision depends on the purpose and object of the provision which is intended to be achieved. So these were the primary rules of interpretation which is followed at every stage of law.